Hey all, Nicholas Steffen here again with another video for Project Wake Up. In my last video I touched on a bit of a background as to how I came about with my research and the flyers and documents I've done up. And here with you tonight I want to discuss my 3-page 60 question Launceston Community Law questionnaire. And just at the top of it here on the first page I've put on there, by stepping outside the laws of the Commonwealth of Australia, codes and ethics, code of conduct, scope of office, a person changes the matter from public into private, meaning that you can be held liable in their own private capacity. And just under that I've put a couple of verdicts from the Nuremberg trials, and one of them is, and this is from the Chief Prosecutor of the Nuremberg trials, Justice Robert H. Jackson. It is not the function of the government to keep the citizen from falling into error. It is the function of the citizen to keep the government from falling into error. And another Nuremberg trial verdict they'll put on there, which heavily affected a lot of the Nazis with their war crimes, and even though they were taking orders, they're still responsible for them, and I'll read it out to you right now. Under the Nuremberg trial verdicts, one of the results of the Nuremberg trials that have been adopted worldwide stated that even if you are obeying orders when committing a crime, you are personally guilty of that crime. This is confirmed by Commonwealth or state laws such as the Criminal Code Act 1995, the Crimes Act 1914, and the Criminal Code Act 1924. So all you police sergeants out there, the police commissioners, you're all responsible for your subordinates and their actions. So any wrongdoing that they do from your orders, you can also be hung and held liable for their actions. And these 60-odd questions have been put forward to lawyers, barristers, QCs, magistrates, police commissioners, prime ministers, governor-generals, where they refuse to answer, which goes to show that they may be committing acts of treason, treachery and sabotaging our Commonwealth of Australia Constitution Act 1900 UK. The first question I've got on here is one of the biggest obvious ones that asks everyone to help try and wake up the rest of Australia. Is the Australian government, Australian Parliament, a de jure government parliament, and are they the same Commonwealth entities as it would have been at Federation? Our Commonwealth Constitution Act 1900 UK describes our government as being the government of the Commonwealth of Australia, and the Parliament being the Parliament of the Commonwealth of Australia. And as a lot of you know anyway, in 1973, Gough Whitlam, under their Acts Interpretations Act, removed our Parliament and our Commonwealth government and replaced it with their corporate ones. Question number 2. Is the Australian government a corporation registered to the US Federal Reserve Bank, Central Index Key number 805157, and each individual state and territory have their own registration numbers on there also? If you go into the securities, sec.gov, and do an EDGAR search and type in Commonwealth of Australia, it'll appear as the all uppercase Commonwealth of Australia. And as you can see from there is a company registered to the US Federal Reserve Bank. And on there you can find tax filings, company filings, tax returns, reports, etc. And it's existed on there since 1934. The all uppercase Commonwealth of Australia is not our constitutional de jure Commonwealth of Australia that you would write in proper English descriptive text. Question number 3. Does all legislation that is relied upon by the Australian government carry the correct royal seal and assent according to law? Our Commonwealth of Australia Constitution Act 1900 UK states that at section 58 that the Queen gives royal assent. Queen Victoria or her heirs and successors sit under the imperial crown of the United Kingdom of Great Britain and Ireland. Queen Elizabeth II sits under the United Kingdom of Great Britain and Northern Ireland, which is the St Edward's crown. And as I touched on that in my last video, there's a difference in the crowns, and our Anzacs fall under the raised arch one, which is the imperial. And as you can see from when I showed the Tasmanian police badge, they've got the St Edward's crown, which is the dipped arches. Question 4. Has all legislation been passed since Federation been passed under our de jure government of the Commonwealth of Australia and our Parliament of the Commonwealth of Australia? Our Commonwealth of Australia Constitution 1900 UK states that we have agreed to be united in an indissoluble federal commonwealth under the Crown of the United Kingdom of Great Britain and Ireland. Has all legislation been passed since Federation, and this is question number 5, in accordance with Commonwealth Statutory Rules, Volume 3, Judiciary to Navigation, 1901 to 1956, on page 2609, Orders 15A. Orders 15A states that an Act legislation also has to be an Act legislation of the UK Parliament. And on one of my earlier videos where I touched on the Tasmanian magistrates not sworn in correctly for over 30 years, I mentioned the 1869 Promissory Oaths Act, which is the Tasmanian one, and also the 1868 Promissory Oaths Act, which is the UK one. Question number 6. Has all legislation been passed since Federation with respect to the Authorised King James Bible? Now, de jure, Commonwealth of Australia is born out of the Authorised King James Bible, and you can't be a constitutional lawyer without knowing this. And I might just cut the video here, folks, as it's already up to 6 minutes and it's going to take quite a while to get through all 60 questions, so hang around for a part 2 and possibly part 3. I do this out of love for my fellow man.